Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana, and this will be segment 3 of the Stanford victims civil litigation against the OFI, and we're going to be covering basically what transpired, for the highlights of what transpired in court yesterday, July 29th, as well as today, July 30th. I waited until after today's proceedings were over because today was a short day, with the court being dismissed at around noon. Also, the court will take the day off on Friday because one of the jurors had to take or needs to take a medical trip, and so Judge Johnson went ahead and approved that, and so court won't convene on Friday, August the 2nd. So everyone will get a 3-day weekend. So let's get started with the highlights from yesterday's court room proceedings. And first of all, you may remember that I had talked about when Judge Johnson's decision with regard to the wording in the jury instructions didn't go the OFI's way, that at 9 o'clock that morning they asked Judge Johnson to send the word file to the Phelps-Dunbar office in order for them to begin the process of a writ application. Yesterday morning, Judge Johnson asked them if they had any update on the progress of the writ application, and they informed him that they had made the decision not to submit a writ application, and that they felt like any differences over the jury instructions should be able to be satisfactorily resolved prior to finalizing those jury instructions. So the writ application was a false alarm, and so the wording will, for now, remain as Judge Johnson approved the final draft, to which Mr. Price, the lead attorney for the plaintiffs, had no objection whatsoever. So let's begin with the first witness, and she was the one that occupied a significant amount of time. But I need to emphasize that this is a videotape deposition. She's not live in the courtroom, okay? So the jury is watching a videotape, and they're seeing excerpts of that deposition. And this is actually Phelps-Dunbar putting this on, and they are putting this on as part of the cross-examination of her. That took about 2 hours, and I'm going to have some things to say on that, but let's go ahead and get started about this. Was Miss DeRee Allen, and she was a 1975 University of Arkansas accounting graduate, and she was literally the field level examiner for Stanford Trust. Now, Stanford was a standalone trust. Most times trusts are going to be part of a banking operation. You may remember many days Capital Bank and Trust, Am Bank and Trust, American Bank and Trust. Normally trust operations they're separate and distinct from the operations of the bank, but normally they are in affiliation with the bank. This was a standalone trust company, and she testified that there were a maximum of 2, Stanford being the primary one. And remember, they were chartered in 1998. In fact, John Ducrest he was subsequently longtime commissioner of financial institutions, but we'll get to him later. But he had said there were 2, and then one sought a national charter, and so Stanford was it. Remember, this is Phelps-Dunbar putting this video on, and they're doing it as part of the cross of Miss Allen. But yet all of the questions on this video were posed by Mr. Price. And I really want to commend Miss Allen. I'm going to tip my hat to her. Because I don't know how she held up. the line of questioning and the repetitive questioning of the same question over and over and over and over and over and over again was infuriating. And I have to believe that that was probably done, an act that Phelps Dunbar did to influence the jury from the vantage point that she was basically being, I don't want to use the word badgered, but Mr. Price didn't like the answers she would give, and so he would say, well, now wouldn't that be, and she would reiterate over and over again. Now, I'm going to focus on a few of her points because I'm just telling you, this thing took 2 hours to play, and I hope I can cram it into a few minutes because that's all really that was of substance to it, because again, Mr. Price did not like the answers she was giving, and so he basically bantered back and forth with her, and she didn't budge. I do want to emphasize that at one point she finally, just from literally from darn near exhaustion, just held her head down and said, "Haven't we been through this before?" And I said that to kind of replicate what she said, and that will give you some idea of how enduring this was. I could not have held up. I'd have probably lost it at some point. When you get asked the same question over and over, something's got, sooner or later, somebody needs to use some common sense, and let's move on. But at any rate, and just if anybody's wondering, the jury is comprised of 9 males and 3 females, and then there are 4 alternates. And I'm not going to say this may have been an attempt to cause the 3 females that are on the jury to view what happened with this young lady in aggravation and perhaps take it out on the final deliberations, but I can't rule that out. So let me go forward. It was very unusual in being a standalone trust. Repeatedly, he said, "Didn't you see a need to perform a valuation on the securities?" This is one of the questions that was over and over and over and over again. And she kept with her answer, as would Mr. Ducrest. We'll get to him in a moment. No. The valuation of a CD is its face value. It's the same thing that had been argued by the Phelps Dunbar attorneys in opening arguments. And it's common sense, to be quite blunt with you. A certificate of deposit, its market value is going to be the face value. If it goes to mature, then the interest is added, and that becomes the market value. And so she over and over emphasized that these things were self-directed IRAs, okay? And the purpose of the trust exam is to evaluate the health and the financial viability of the trust. It's not to get down to individual who are having those self-directed IRAs to go and say, well, gee, do you really think you're being wise to invest in this security? Do you think it's being wise to invest in that security? She emphasized, that's not our place, that's not my place. She said, if people want to invest in something, whatever it may be, if they want to invest in the entirety into AT&T stock, that's their prerogative. It's not my place, and it would be a violation of the Bank Secrecy Act to go in and to try and contact the individual members. So she emphasized that repeatedly. I talked about the fair market value being the face value. That went on ad nauseum, as did the, was there a need to alert or a need to warn, or things of that nature. again, she emphasized that what this trust was primarily comprised of was a whole bunch of accounts that were self-directed IRAs, and she indicated we did not do anything wrong. Now she's the field level examiner, okay? Now she hails from Bastrop and Farmerville, so that was, I don't know. You have to, I want you to envision this for a moment. You've got the entirety of the SEC and all of its, remember we talked about Mr. Blunt making the point that the resources of the OFI pale. I mean, it's minuscule compared to the Fed agency. Well, I think this is a perfect example. She is the only examiner for this, okay? So she is the field level examiner, and that's it. There's no other. She's solo, okay? Now, she had plenty of training for this type thing, and I'm sure was extremely well qualified to conduct the exams. But as she drove home, the scope of our exam is looking at the income for the trust, and we'll talk in just a moment about the fact that they weren't going to be allowed to charge fees on this, and so then there would be the question about how are you going to keep this, how are you going to make this thing viable without being able to charge the fees, and there was testimony today by a young lady named Deidre Moore, so I'm going to push that back a little bit because she got far more into the specifics of that. So then Mr. Price wanted to basically nudge her, and I do mean nudge, because he was nudging her into trying to get her to testify the way he wanted her to testify, and it just didn't work. But he said, shouldn't these CDs be viewed as unique assets? Now, unique assets the reason he's trying to get that out of her is because if it was a unique asset, that being a limited partnership, real estate, then that would trigger the need for independent evaluations of the market value of these. She said no. Her testimony was matched subsequently by two other former OFI officials because a CD is not a unique instrument. Now, Mr. Price tried to emphasize that, well, because of the nature of Stanford's operation, should it have not have been viewed as a unique item? And she said no, this was a CD from a bank in Antigua, and there were brokers brokering these CDs, and so the onus would be on them to have known, okay, how safe this was. But she said the fact that it is a CD has its traditional meaning of a CD, and therefore does not fall under the category of a unique asset. She did indicate that OFI had been contacting the Stanford group to get Stanford International Bank financial information. And let's see, let's go to the next page here. Give me just a second to read. She said that she had went under the assumption that the brokers who were the ones that were officially selling this stuff, that they had been SEC approved. Here's one key point. There was a little pause in there was one point of a little bit of where she actually enjoyed, and that was with regard to Jason Green. Now, we talked about great Jason Green in the prior episode, so I'm not going to elaborate upon him, but she said, Jason Green, when I would have my discussions with him, there was no reason for me to believe he wasn't of good character, and Mr. Price apparently said under his breath, that was your first big mistake. And she looked over at him and said, now I may have made a mistake. She said, what did you say? She said, did you say that was my first big mistake? And she had a smile. You know, that was the only time of relaxed. Everything else was tense, and it was very painstaking to literally watch this even 11, 12 years after the fact, especially when you consider I'm cramming it in, but it was 2 hours, okay? But she volunteered of her own accord. One thing, and he said, now the investors, and she said, you really don't want my thoughts on that. And she then volunteered. She said, look, these folks made these investments thinking they were going to make a ton of money. You know, and I had previously said that 7.5 versus 4. I've read accounts of as high as 11.5. So yeah, she made another quote a little later, and I'm gonna get to it in a second. But you know, she basically said, you know, they put up that money because they thought they'd be getting she said they thought they were going to make a ton off of it. And so she said Jason Green was based in the Stanford Trust brokerage operations and brokerage side. He had a very large book of business. And let's see. And that he knew that these people had the minimum net worth of $1 million, exclusive of the home, to even be allowed to participate in this. And she said we would make sure that there was the signed page affirming that fact. We would make sure there was valid driver's license for all of these account holders. She said everything else beyond that is the broker's responsibility. And she said, and it may not even be required of the brokerage. She said, it's much like a tax return. When you sign that thing attesting that this is accurate, then it's believed to be accurate. And so, and you know, if people were signing these things saying, hey, I have a minimum $1 million net worth, or I have over $200,000 in income if you're single, $300,000 if you're married, apparently may not be a requirement for anybody to go out and validate that. There was talk about an email between her and Deidre Moore, but I'm going to hold off on that until we get to the Deidre Moore testimony. Let me skip over some of this, otherwise this video is going to become way too long. She emphasized that they kept being told that the financial information would be available, but up to a point, and then she said we determined that it was just not going to be readily available, and that's when we did start to intensify our concerns, particularly because, as she repeatedly emphasized, of what was becoming a very large concentration of holdings in these CDs. We'll get to that further. Mr. Ducrest had to testify in that regard, and we'll get to it next. But she did conclude, or this is one of the last quotes I wrote down. She said, look, here's the fundamental lesson to be learned here. She said, I guess we should all take a lesson from our grandmother when they tell us not to put all our eggs in one basket, and especially putting those eggs in a company that's headquartered in a foreign country. I can just tell you, and of course it's easier to say that into a camera on a video deposition, and it might not have been as easy when you're seeing these folks in court, but I can just tell you that there are plenty of people who have those sentiments. I mean, I'm just going to lay the cards on the table. I've talked with a number of people that they don't have any sympathy for what happened here, because you know the argument is that you've got to be intelligent to have amassed this kind of money and to put all, as I said, all the eggs in one basket, especially in a foreign company. Okay. This note is out of order, so let me put it to the side. I've got to go grab a separate set of notes. This will be the last note. I have it out of order. I apologize for that. So let's commence. That kind of wraps up a part of the biggest, what I consider the biggest part of yesterday, because next up is Mr. John Ducre, and he was the Commissioner of Financial Institutions from 2005 until 2021. Yeah, I need to start with this page. This was, I believe this was still part of Monday, so we've not yet got to Tuesday, but Ducre was the central focus this morning. So, but let me get some of the preliminaries out from yesterday, just so everybody can know who John Ducre is. I certainly remember that name. He started at OFI in 1985. He is the first cousin of John Breaux, former Senator John Breaux. So some may say, okay, I guess we know what you mean about political animal. I'm just telling you the facts. But he certainly served his time. He had been with OFI since 1985. He became the commissioner of OFI in 2005. A lot of what Mr. Price quizzed Mr. Ducre on, and once again, this is on cross. A lot of what Mr. Price quizzed Mr. Ducre on dealt with things that his predecessor, John Travis, who had been the OFI commissioner the preceding 4 years, what was a directive. Now, Mr. Price wanted to say, made this policy, and Mr. Ducre would repeatedly say it was not policy, it was a directive issued to the Stanford group. And Mr. Price, very briefly for those, well, almost everybody's not a banking. Well, there's some folks watching this that I can tell you are going to be bank examiners, some of my former colleagues. Banks are rated from 1 to 5. It's called a CAMEL rating. CAMEL is short for Capital, Asset Quality, Management, Earnings, and Liquidity. Trusts have a very similar type setup, 1 to 5. 1 is being, hey, there's no problems that we can spot here. 2 being, hey, there's some problems, but they're easily correctable in the normal course of business. 3 is some more challenging problems, still should be solvable. 4 being that, hey, look, this is starting to get pretty serious, may not be solvable. And 5 being this institution appears to need to be closed because it's operating recklessly and or has severe capital problems. And so the ratings, the categories are slightly different for a trust, but most of Mr. Price's hammering, or I'll strike the word hammering on that, quizzing of Mr. Ducre dealt with Stanford's ratings, Stanford's reports. And remember this, if it hadn't been for the Supreme Court, we wouldn't have seen a lot of the things that I did get to see in this morning's testimony. And I'm very glad, I'm very appreciative of the Supreme Court for doing this, because to have known that I had to be thrown out of the courtroom and not be able to see some of these things, I just don't think it's right, and I'm very glad the Supreme Court did not go along with that. You can infer what you want about the fact that Judge Johnson and the First Circuit was willing to go along with it. As far as my perspective, remember the key things, the tight timeline that we're talking about here. Mr. Price says, if y'all would have just done something before January 1st, 2007, all of my 900 plus victims wouldn't have lost a dime. Now, obviously, he's trying to force Mr. Ducre to say, yeah, we should have taken some action here. It would have been a different set of people holding the bag. I mean, it's not like, you know, okay, this thing was a pyramid scheme, so somebody's going to be left holding the bag. It would have been a different set, and perhaps not as much, well, definitely not as much money, but be that as it may, the OFI is stressing the fact that there were little reason for concern up until that June the 5th, 2008 meeting at which it was invited. And it was a meeting of the FBI, the Securities and Exchange Commission, and it was at that meeting that said, look, the SEC's been conducting an investigation for several years on this, and it's starting to look like this whole thing is a Ponzi scheme. Now, believe it or not, that I spoke with one lady who wrote her check in July of 2008, and so Mr. Price is trying to say, surely at this point that everything should have been shut down, or that should have been barred from doing this. And certainly you can't justify one rating. Remember, one is no problems. I mean, well, yeah, basically no problems. Two being correctable in the normal course of business. Surely you couldn't justify a one rating once it was revealed that, hey, this whole thing may be a Ponzi scheme. Mr. Ducre's reply was that at that point we did not have any substantiation for sure that it was a Ponzi scheme. So let me see one more. It looks like from my notes on July 21st of 2008, it was a cover letter indicating there was a cease and desist order, or maybe Mr. Let's see, not know for sure that it was a Ponzi scheme. Strike what I said on the C&D, because I'm not positive whether that was Mr. Price saying there could have been, or there actually was. I'm sorry, y'all forgive me for that. I think because it says accompanying the exam, and so I'm thinking he may have said, this is why I wish we could have cameras in courtrooms. It really infuriates me that we have to be relegated down to the accuracy of my notes, and I do the best I can. I'm just not sure. So let's just pretend I haven't even mentioned anything about a 7/21/08 C&D order. So John Travis, his predecessor, had issued the directives that look, you can't be charging fees on this. Apparently the income was going. The income would go down if there were no fees, so what about the future? Mr. Ducre indicated at that point it could not be deemed that this was a reckless operation. Remember, Mr. Price is trying to fight for reckless or willful indifference. Again, OFI wants gross negligence, but they decided not to file that writ application. Mr. Price emphasized that we're talking about $320 million spread across 13 accounts. Now that definitely covers Mr. Ducre through yesterday. Now we picked it back up with Ducre this morning. He emphasized that, hey, we acted reasonably. Mr. Price said, well, let me ask you this. Do you view a CD that was held in these self-directed IRAs to be identical to or equal in risk to a CD at JP Morgan Bank? Mr. Ducre's response was yes, because this is a country with a regulatory structure. I wrote that verbatim quote down. Quote, yes, because this is a country with a regulatory structure, unquote. Mr. Price then asked him, were you aware in 2004 that Whitney Bank had suspicions about the Stanford Trust and therefore they canceled the relationship with them? He indicated that he did not have any knowledge of that. he being Mr. Ducre, he did not have any knowledge of Whitney Bank canceling its relationship. He stressed that from January through June of 2008, we continued to try to get financial information and even tried to see about getting someone to go to Antigua. In fact, there was a November, let's see, it was, well, no, I'm gonna save that for Deidre Moore's testimony. Otherwise, we'll be overlapping a lot of things here. Mr. Price said, I wrote down the August 18, 2003, that there was a notation about IRS requires fair market value annually. But that's only if a security is deemed to be unique, which again, Mr. Ducre reiterated what Ms. Allen had said, that there's absolutely no reason to believe that a CD falls under the category of a unique asset. So now we start getting into some of the reports. In August 18th of 03, there were 38.4 million in Stanford Investment Bank CDs that Stanford, there was no charging for fees. In August the 2nd of 04, that report was issued, and the CDs had escalated up to 52.659 million in self-directed IRAs of accredited investors. There were no fees, but that other assets were held by the same customers for which there were fees being charged. Let's go ahead into the 9/5 of 05 report. Let's see. We were at $97,723,679. There was a itemization that, hey, if we're dealing with anything like limited partnerships, real estate, that would be considered a unique asset. But Mr. Ducrest again emphasized you do not see CD amongst those listed in that itemization for unique assets. So let's skip to the August 14th of 06 report. So we're now up to 166 million. As you can tell, it's rapidly escalating. Now Mr. Price went ahead and put a PowerPoint up, and you could see that dramatically. And we haven't even gotten to where we're nowhere near the peak, but I'm flying through this because I don't want to make the video too excessively long. August 14th of 06, we're at 166 million. The Camel ratings in 05 was a 1. That means, hey, good as they come. 06 was a 1. Now the 07 report, now bear in mind that wasn't issued until quite late in 08, but it was a 2, which just still means, hey, these are correctable problems in the normal course of business. And Mr. Price was hammering the fact that even with this meeting that was held in Fort Worth, Texas, where the OCC opened up that we've been conducting a years-long investigation, this may be a Ponzi scheme, you still deem this to be a 2-rated trust. Based on what? And he said, but based on the fact we had no proof at that point that it was a Ponzi scheme, and the evaluation of the point in time of when we assessed Stanford, which was well before the report was issued, justified a 2 rating. The categories that were not rated 1, normally you would never get to see this stuff. You would never get to see a bank's ratings. That's extremely confidential information. And this is the kind of thing that we wouldn't have gotten to see had it not been for the Supreme Court's ruling. That report dated, I have it as 9/17 of 07. They gave management a 2, and asset management a 2, and compliance a 2, and the overall rating was a 2. Let me go to the next set of material. We're wrapping up, folks, if you're wondering, and trust me, I'm just scratching the surface. So 6/30 of '07, there was a 72.8% concentration, and the report said, quote, "There is concern for the lack of diversification and the associated risk with that concentration. The SIB CDs are apparently being issued, quote, without proper due diligence, unquote." This is all from the report for the June 30th, 2007 ending financials. The Stanford Trust is not performing the due diligence, and then, quote, "There may be a need to reduce risk in order to protect the reputation and capital." And then in 9 of '07, there was a $310 million total assets, with $263 million of that being the self-directed IRAs. And then there was the 7/21/08 letter, which makes me now think that that was Mr. Price saying, couldn't it have been the right thing to do to have said, look, we got to suspend this for the time being, pending resolution of some of this. But so we got the 7/21/08 OFI letter, where it recommends, number one, getting an independent valuation of the Stanford International Bank CDs. Number two, verifying that these investors are accredited. And number three, making sure that this does not represent an inordinate percentage of the total portfolio for these individuals. You know, well, I guess the horse is kind of out of the barn. Well, it's way out of the barn. But anyway, there was the fact that that 7/21/08 letter did recommend these three things. Again, we wouldn't see any of this without that Louisiana Supreme Court ruling. But let me just say this. Mr. Ducrest's statement that we had no proof that it was a Ponzi scheme, you know, and you know, these ratings of these banks, which normally you would never see. But just think about it. Back in the mid-2000s, do you just think about Standard & Poor's and Moody's? How many of these, I mean, absolute subprime mortgages that were literally the lowest tranche of some of this stuff, and they were giving them AAA ratings. And those were made known. It gave people a false sense of security. And we see what happened. It was a complete meltdown. And in fact, it was that whole panic is what triggered the Madoff being exposed, in my opinion, probably caused this to collapse. Everything started collapsing because people said, look, I got to get my money, period. So I just brought that out to say, even if you were using a highly respectable ratings agency, that this is what they do. Because if you ask me who bore the biggest act of responsibility for the mortgage catastrophe that we had in that year, and a very near complete financial meltdown of our entire system, when you have weekends where Hank Paulson is having to gather together several key executives from big banks to avoid one collapse after another, you know, and Merrill Lynch is acquired by Bank of America in a rush together shotgun marriage. Bear Stearns collapses and is not bailed, Bear Stearns I think wasn't, Lehman was, I can't remember, or maybe Lehman wasn't, I can't even remember which one. I know one of them was, one of them wasn't, you know, and I mean, so to believe that the OFI, especially given the lack of resources, could have been on top of this, in my versus the SEC and all of its manpower, and the fact that for years long there had been an investigation, in my opinion, to try to put all of this at the feet of OFI is a tall order to fill. Particularly when the scope of what they go in to do as Miss Allen pointed out, is not to go and delve into and pay financial advisor and say, I don't think these people ought to be investing in this. This is a free country. You can take whatever risk you want. And while some of these brokers may have been absolutely nothing short of scoundrels to put folk into this, whether they knew or didn't know that, hey, now Stanford was running a Ponzi scheme. People have a right to invest, and when you're being given an exorbitant return, watch out. That's all I can say, and this is proof of it. Mr. Ducre kind of wrap things up with, hey, we don't have any proof of a Ponzi scheme. He said they had an ongoing investigation because of concerns about the concentration, and that had, at least well, maybe he was referencing the ongoing investigation by the SEC, but he said, as you see, 9 months later, the whole thing collapsed. Now, we've covered everybody, and I apologize, I know this one is long, but we've covered everybody but Miss Deidre Moore. She was called in today, and I'll try to keep hers very brief. Mr. Price indicated, hey, we've never met. That's correct. She graduated in May of 1986 from Southern University with an accounting degree, and she started to work at OFI. Now, I wrote down May of 1986. I'm sorry, my bad. She graduated in 1985 from Southern with an accounting degree and went to work at the OFI in May of 1986, and then she retired in 2016, so she was there for 30 years. At the time of this whole Stanford situation, she was a review examiner. I remember her name very well. I never met her because when you're a review examiner, you're going to work you don't work out in the field. She referenced a gentleman named Larry Walker that was with the Texas Bank Examiners, and on November 9th, 2005 email, I believe it entailed that, hey, we're not going to end up going with y'all to try to make a trip to Antigua to try to investigate further on this. Mr. Price said you are distinct amongst anybody because you are the only one that I'm aware of. You're the only one I've met who has actually met Alan Stanford. And so he did talk about a July 31st, 2001 meeting that Ms. Moore held with Mr. Stanford and others. And she said the reason that meeting was held is because they did not have the minimum $2 million in capital that was required for having the standalone trust, nor did we see any definitive plan. I'm quoting her verbatim, nor did we see any definitive plan to raise that within a reasonable time frame. And so Mr. Price went to great lengths to show the total incomes of the trust, and then if you backed out the fees that Stanford was putting in, it would be that, for instance, in 1 year, it was $381,000 net income, but if you backed out the $977,000 in fees, you would have roughly a $600,000 loss. In another year, you had a net income of $856,000, but if you backed out the $1,812,000 in fees, I believe that was in year 2006, there would be roughly $1 million loss. And so it was basically without these fees from the other accounts held by the same, the fees were not being paid by the self-directed IRAs, to my recollection, because there was such an issue about, hey, you can't charge fees, a conflict of interest, so forth and so on. But at any rate, her testimony was put up there to basically say, look, this whole thing would have collapsed long before it did without these fees that Mr. Stanford was managing to pump into this to meet a requirement to try to get to the $2 million. And so that is the high points of everything. This is way longer than I normally make these videos. If you made it all the way through, I appreciate your indulgence. I may not have had things 100% accurate. In fact, I think on that July 21st, that was Mr. Price saying, couldn't you have, said that, look, we need to suspend this for the time being. I did my best. There is no interest in this case. I mean, I don't know any other way to say it. You max out at maybe, you're lucky to get double digits of people in the audience. This morning there were 4. The Advocate did do one article. They've not been back since. I spoke with that reporter earlier today. He did indicate he was probably going to come in at least for a while tomorrow, but there's no interest. And so if you don't like my coverage, well, I guess I'll just have to say, well, you get what you pay for. I'm trying to do my best, but this is not easy material to cover. I have an advantage since I was an FDIC examiner. I also, because this is a blog, I can throw in some opinions at times. I will make note that Judge Johnson said, now look, of course this is the normal instructions to the jury. Don't make any effort to go out there and find material on blogs or social media or whatnot. And in his instructions he said such material can be highly opinionated, inaccurate, and I thought, okay. Mine does time to get to be opinionated. I try to make things as accurate as I possibly can. But at any rate, I think this jury is to be commended. This is not an easy, and they still have, I don't know, a week and a half or so to go. We haven't even gotten to the defense. We're still on the plaintiff's side. Excuse me. I will say this: if those jurors think this is tough slotting, have been down there in that New Orleans trial for Shiva Akula. This would seem like highly motivating and interesting material compared to those Medicare codes. So, as my mom used to always say, things could always be worse. And it's not like any jurors complaining. They all seem very attentive, very diligent. But I'm sure they have to wonder, okay, how much more? Thank you for your indulgence. I know this is close to 50 minutes on this, and I appreciate it if you made it through. And we will look to bring you segment 4 of the Stanford trial real soon. Thank you so much.